Be sure you have your evidence ready. If you're going to screen share it, whatever you're going to do, make sure you can do that. And if you need any help getting your discovery or presenting your evidence, Jared Regier for the state. Miss Leslie appears in person and per se. Miss Leslie, is that you?
Yes, Your Honor.
Where's your attorney? Are you going to have an attorney represent you?
I am presenting myself.
You know you have the right to an attorney, to hire any attorney of your choice. If you cannot afford to hire an attorney, you can apply, which I think you've already done, but you did not request an attorney, is that right?
I did not request an attorney. That is correct.
You want to proceed on your own behalf, and you can do that. No one's going to stop you from doing that. But is anyone making you give up your right to an attorney today by any threats or promises?
No.
You understand you can hire, and if you can't afford, you can apply for court appointed. And if you qualify, one would be appointed. Do you understand that?
I comprehend, yes.
You do not wish to have an attorney?
I do not wish to have an attorney.
All right, I will show on the record that you've waived your right to an attorney and that you're going to proceed on your own behalf. So how do you plead then, Miss Taylor, or Miss Leslie, I guess it is. I'm sorry, I'm just saying it wrong. Miss Leslie, how do you plead to count one, interference with law enforcement officer?
A plea would be inappropriate at this time. I'm hoping to request a continuance.
Why would a plea be inappropriate at this time?
Okay, so Your Honor, for the record, I am Sydney Taylor Leslie in propria persona sui juris. I am here by special appearance only and not making a general appearance. I reserve all of my rights, remedies, and objections, including but not limited to any objection to jurisdiction over my person. I require a continuance in this matter. I intend on filing a subpoena for body cam and cruiser footage. There are facts in dispute on this matter that I'm looking to clear up before the matter can continue further.
All right, I will grant a continuance for you to obtain discovery, but if you don't know how to do the things you just rattled off, you better have an attorney do it for you. Do you understand?
I understand.
All right, Mr. Aguirre, do you wish to be heard before I pick the date for this?
This is the moment that matters most. The judge doesn't rush. He confirms again and again that the defendant is voluntarily giving up her right to an attorney. No pressure, no confusion, no excuses later. Once that waiver is entered, the court is no longer responsible for helping her. Every mistake from this point forward belongs to her.
Your Honor, this does appear to be the first setting since the first appearance hearing before Judge Hart back in June. If the court is prepared to set this matter over for discovery purposes, the state does not object. I'm not sure if the court wishes to set that matter for merely control at this time, but I'll defer to the court on that point if the court will find that the bond is being continued and this continuance is at the request of the defense for speedy trial purposes.
All right, Miss Leslie, you're charged again with interference with law enforcement officers, a Class A non-person misdemeanor, driving without insurance, a Class B misdemeanor, and driving without a license in your possession, an unclassified misdemeanor, as well as failing to register your vehicle, another unclassified misdemeanor. The judge would have gone over these with you at first appearance. You want to go over them again as far as the penalties?
No, thank you.
All right. And you've indicated you want to exercise certain rights that you are entitled to and encouraged to. But as I said, an attorney could certainly help you carry out those rights. And you said you do not want that attorney?
That is correct.
Okay. Well, I'll have the record and the docket notes show that you have waived your right to counsel and that you know what you're doing. Now, then, do you want to set it for trial, Miss Leslie, or do you want to get the records and look at them and then set it for trial?
I would like to have a continuance, perhaps for discovery or an evidentiary hearing if possible.
Well, I can continue it for both those readings.
Okay.
For both those readings, to give you time to get all your discovery, the dash cam, body cam things you were mentioning.
Okay.
And then we can also set it for trial. So when's a good trial, 1:30 trial date, Jim?
Your next one will be September 24th.
All right, you'll need to be back here with all your witnesses September 24th, 2025 at 1:30, and that will be by Zoom again.
Your Honor, if I may just get a little more time due to the fact that I'm going to be submitting the subpoena and I'll need discovery, and I need to just review it so that I can have adequate time to present myself for my defense.
Well, that's 30 days. You don't think that'll be enough? How much time are you asking for?
I'm hoping for at least 60 days.
Jen, do we have 60 days?
Then the familiar sovereign citizen script appears: special appearance. No consent to jurisdiction, reservation of rights. It sounds strategic, but legally it changes nothing. The judge allows a continuance only for discovery, not because the arguments hold weight. This is the court signaling: speak real law, or face real consequences.
We have October 22nd or October 29th at 1:30.
Which of those do you prefer?
I would prefer October 29th.
October 29th. This is continued to October 29th at the defendant's request. Is that over your objection or not, Mr. Ricky? I don't remember any objections.
Your Honor, if the court is prepared to set this matter for trial, the state does not oppose that, but the state will be requesting a ruling as to whether or not the bond is to be continued and if this continuance is at the request of the defense.
Court does find this request at the defendant's, and the time will count against the defendant for speedy trial purposes. The matter is continued for bench trial to be heard and to be commenced August 22nd, 2029 at 1:30 p.m. via Zoom. So Miss Leslie, it's going to be here by Zoom. Right? Be sure you have your evidence ready. If you're going to screen share it, whatever you're going to do, make sure you can do that. And if you need any help getting your discovery or presenting your evidence, you're always able to hire an attorney. And if you can't afford one, apply, but do it well in advance of the trial so that you can get the application completed, returned, and the court can appoint your attorney, and you and the attorney can have time to present your case.
Okay, yes, Your Honor, I did hear you say October 22nd. Was it the 29th that I had requested at 1:30?
You did, so I'll make it October 29th. Jen, you said
Thank
either
you.
of those. You said either, and she picked the 29th, correct?
That is correct, Your Honor.
It'll be October 29th at 1:30. Now, Mr. Regier will be subpoenaing witnesses himself for the state. And if you find out or decide you don't want to go with a bench trial, let him know as soon as you can so he can cancel any of those witnesses that he may have coming in.
Thank you, Your
Okay.
Honor.
You're welcome. And don't forget, you can look at diversion and see if that's an office option. You can call the county attorney, but definitely look into that issue of an attorney.
Okay, thank you, Your Honor.
You're welcome. Anything further from the state, Mr. Regier?
Your Honor, if the court is continuing the bond in this matter, I have nothing further at this time.
I am continuing the bond, all existing conditions plus the new ones I've stated on the record today.
Thank you, Your
And
Honor.
you're welcome, and Miss Leslie is excused at this time.
Thank you, Your Honor.
You're welcome.
Your Honor.
By the end of this hearing, the court sets firm trial dates, continues bond conditions, and puts full responsibility squarely on the defendant. This case highlights a hard truth courtroom procedure beats internet theories every time. Sovereignty arguments don't stop misdemeanor charges, and self-representation turns small mistakes into big problems once trial begins.